Members, let's resume the meeting. Well, I did not uphold very strictly the speaking time limit in the first half of the meeting, but now we're into the second half. I will be stricter, and please make sure we have sufficient time for the administration to respond to your questions. So let's resume about renewal of registration. We have had a full discussion, so may I now move on to Division 3, issue of replacement registration card, Section 14. Now, if there is a change in the name of the engineer, or if the original card is lost, destroyed, defaced, or damaged, then if applicable, the original card should be submitted to the FSD, and then the director will issue a replacement card, and the original card will become invalid. Mr. Andrew Lam. Now, according to Section 32, Bracket 2, cards were issued. Now here, it provides the card in hard copy form. That is, if the engineer has an has a hard copy of the original card, it will be submitted to the director. What about e-cards? Mr. Yong will give you details. If the name is removed from the register, then of course there will be adjustments made. For e-card, no submission is necessary for replacement. Mr. Yong. Now for e-registration card, it comes in the form of a PDF, and a QR code will be shown to identify the class of the RFE. The way the QR code works is that if you access the government website and if you scan the QR code of, you'll get information about the RFEs in question. Any change or cancellation of this e-registration card would mean a further change in the computer system of the government, and that if you scan the code again, a red alert will show up indicating that the card is no longer valid. So like Mr. Andrew Lam said, if you have the QR code on the hard copy of the original card as well, then there is no need to ask for the original card to be handed back. Right, but on the original card in hard copy form, it may come with a name, and like the member said, well, no further information is provided, unlike having a QR code. So perhaps we'll go back and give it a thought. The idea is that if you use an e-card, you can then access the government website to check the information. Now for the original hard copy, there is no need to scan any code. All the information will be provided. Right, because we talked about the vehicle license, and operationally it's a mess. So please make sure it's as simple as possible. Ms. Doreen Kong, what if the card is lost? Will the engineer be asked to make an affirmation or take an oath? Right, if it's claimed to be lost, we'll ask for proof. For example, the engineer should report the matter to the police. Please continue. Next, about removal in Division 4. According to 15 bracket 1 and 2, the director may remove the person's name from the register if satisfied that one of the grounds set out in 16 is satisfied. That includes Section 16(1). That means an order made by the disciplinary panel or committee to remove the name, and also 16.2, that person has ceased to be an RFE or ceased to be qualified for as an RFE. The person has not renewed the registration or ceased to hold the qualification, etc. Back to Section 15, the director must remove the person's name from the register if one or more grounds specified in 16.2 applies. The director must inform give the person a written notice of the intention to remove the person's name, and that the person will be given a chance within 30 days to make representations, and the director must consider the representations before deciding to remove the name. That's in 15.3. However, the director may also specify that meanwhile the renewal must not be approved. We propose to amend sections 15(2) subject to subsection 3. This will be changed to subject to subsection 4, as mentioned in the paper earlier submitted to LegCo, CB-21471/2025-02. And whilst the name is removed from the register, this person must not apply to be an RFE or make an application for renewal. And according to 15.4, the director, if the director intends to remove the person's name from the register because of a ground prescribed above, the director must give the person written notice of the intention to remove the person's name, and must give 30 days for representations to be made, and must consider the representations before deciding to remove the name. And it is also specified that if the director considers that it's in the public interest to remove the name from the register, it can be done immediately without observing the 30-day requirement. And then 15(6), upon removal of the name, the director must, as soon as practicable after removing the person's name from the register, notify the person in writing. And then subsection 7, the notice must state the period mentioned. And then a notice of intention to remove, and the notice must set out the ground for removal, and also the date on which the removal is intended to take effect or takes effect. If a person is registered on the basis of possessing certain professional qualifications, then if this person ceases to hold the qualifications, the person must notify the director in writing within 14 days after the date on which he ceases to hold the qualifications, failing which it is an offence and is liable on conviction at a fine at level 3, and that it will be on a par with the penalty and the offences in section 13 and 16 for FSI contractors. Mr. Andrew Lam. Thank you, Chairman. Now, on reading the provisions, I have this question. That means the name of this person will be removed from the register for some time, albeit not permanent. Does it mean that this person will be absolved from any liability as an RFE? I go on to section 30, for example. This RFE is required to keep documents for 3 years. Does it mean that the period of removal of the name from the register will be exempted from the calculation of the 3-year period? Is the person required to fulfill any contractual obligation or any moral obligation to support the relevant clients whilst the name is removed from the register? Now, a temporary removal of the name from the register means that certain obligations are still required to be fulfilled. For example, the record-keeping requirement. Once the name is restored on the register, the record-keeping requirement is still to be observed. There is no suspension. So it's a continuous process. We will spell out the specific details in the code of practice. Let me give you another example. In preparing the code of practice, especially in relation to temporary removal of the name from the register, the person should be immediately notified. Of course, it's another matter if the person's name is to be permanently removed. Mr. Doreen Kong. The first question is on 15.5. If the director considers that it's in the public interest to immediately remove the name from the register, then this can happen. Can you tell us an example of this such that the person will not be given a 30-day period to make representations? The next question is section 16.2e. It sets out a number of reasons or grounds for removing the name. And then E, Roman numeral 2. The person was in fact not a fit and proper person who may be registered as an RFE for the relevant class. And then F provides that the person has ceased to be a fit and proper person who may be registered as a RFE. So what happens is that there is a very fine difference between 16E2 and 2F. That is, this person was in fact not a fit and proper person who may be registered as an RFE, and that the other is ceased to be a fit and proper person. In fact, I see the same in the previous section. Why is it that there is a difference between a fit and proper person to be registered as an RFE and a fit and proper person for the relevant class of the RFE? 15(5) provides that the director may decide not to give a 30-day notice if public interest is involved. So that means some very grave situations, such as national security related matters, then the person's name must be immediately removed. Now, about the difference in references to what the member mentioned, that's a point of drafting. I'll give the floor to the DOJ. We should consider the legislative intent and the policy intent. I think we're talking about two different things. One is the fit and proper person for the relevant class, and it's for the FSD to decide whether this person is a fit and proper person. In the same vein, if this person is to be registered as an RFE, then this person must be a fit and proper person. So that's a very fine difference. Well, I think we're splitting hairs. I am perplexed. Let me give you an example. We have an RFE specializing in FSI and another in risk assessment. So what is the difference in terms of being a fit and proper person? Is it that the RFE doesn't meet the qualification requirement? Because you've spelled it out in 16.2D. So I am not sure what 16.2E2 and 16.2F are referring to. Why is it that you have fit and proper persons for the separate relevant classes? We can go back and consider this drafting point. I think we already identified the same for the previous section. Dr. Wendy Hong, a technical question. Section 15.4c. The person may make any representation, and then in section in part 7, division 7, we see another term, appeal. So is there a difference? 15.4c, right? If a person makes any representation within the 30-day period, then the director should consider the representation before making a decision. And then 7 relates to the notice. It's not about representations. So not the same thing, right? Is there another provision that explains what representations mean? Who can make a representation? On what conditions? Right, I think Mr. Ho just now mentioned a scenario. Let's say if this person has remained in hospital and is therefore unable to make any application, then upon the lapse of the 30-day period, this person may make representation citing that he's been hospitalized throughout and asking the director to consider his case. So that means you can make a representation to the FSD, right? I think you need to define what and to whom this representation should be made. I think details will be specified in the guidelines. Subsection 4. If the director intends to remove the engineer's name from the register, according to subsection 4, we will give this person written notice of the intention to remove his name. Then this person will be given 30 days to make a representation. Now, as for the notice mentioned in subsection 7, that's what happens in the next step. The director has decided to remove this person's name, and that a notice should be given to this person as quickly as possible to notify him of the removal. So we need to reference that with 3A, whether it's a permanent removal or temporary removal. So there are 2 types of notices. The first one is that we give a notice citing that we intend to remove the person's name. You have 30 days to make representation. We'll consider that. And then subsection 7, we have considered the representation. The 30 days period has lapsed, and we find there are grounds to remove your name, and we are informing you through this notice. So 3A refers to a permanent or a temporary removal in 3B. These are 2 types of notices. Ms. Doreen Kong. Another question is about section 18.2. If the person ceases to hold the qualification and fails to notify the director, the person contravenes the regulation and is liable to a level 3 fine. Now for section 3.2, if the person fails to or holds out to be an RFE, then on conviction, this person will be liable to a level 5 fine and imprisonment for 1 year. It's also a kind of concealment. Why is it that there is a difference in penalty levels? For 18.2, if this person is registered on the strength of certain qualifications, then after this RFE ceases to hold the qualifications, this person must notify the director in writing within 14 days, failing which a level 3 fine will be meted out. This provision seeks to encourage this person to notify the director so that we can take follow-up actions such as removing the name from the register. For section 3, there is an element of false representation, and it's more serious. We've made reference to other provisions. For example, the penalties for FSI suppliers or contractors.
Administration, please continue. Please refer to page 19, Division 5, General Provisions about Applications. 19, Requirements for Application. The application must be made in a form and way specified by the director. It must be accompanied by any document or information specified by the director and the prescribed fee. If a person obtains registration as an RFE for the person or any other person by means of any misleading, false, or fraudulent representation or statement, the person commits an offense is liable on conviction to a fine level 5 and to imprisonment for 1 year. Section 20, notification of reasons for refusal. If the director refuses an application made under this part, the director must notify the applicant in writing of the reasons for the refusal. Division 6, requirements for registration. Section 21, different requirements for different classes of registered fire engineers. The applicant must meet the applicable requirements specified in Section 22, 23, or 24 for the class to which the application relates. We have already briefed members on the requirements for different classes of registered fire engineers. Simply put, the applicant may apply for registration as a particular class of RFE. 1. That the applicant is a registered professional engineer under the Engineers Registration Ordinance who is in the fire discipline and has at least 1 year of relevant working experience. The second way is that the applicant holds a bachelor degree in any of the following disciplines: say fire engineering, building services engineering, mechanical engineering, civil engineering, structural engineering, and building surveying. These applicants need to have at least 6 years of relevant working experience. They also need to have relevant experience. The third channel is that the applicant has a total of 15 years of work experience. Hang on, Mr. Enkong would like to speak. Thank you, Chairman. I'd like to go back to Section 20. Sorry for lagging behind. I'd like to draw your attention to Section 20. The director must notify the applicant in writing of the reasons for the refusal. 93A and 1015. You already have these provisions. Why do we still need Section 20 about the notification of reasons for refusal? 3A and 1015 already set out very clearly that a reason needs to be given. Why do we still need Section 20?
我諗呢個係一個即係概括。
Thank you. While this is a catch-up provision, we need to settle clearly that the reason needs to be provided in writing. Thank you. I'd like to ask about Section 22(1)(b). Out of curiosity, I'd like to ask a question. It sets out the requirement of bachelor degree. What if one holds a master's degree? Does that person have any edge? Still needs 6 years of relevant work experience. Well, a bachelor degree definitely no problem. The basic requirement is a bachelor degree. Ms. Andrew Lam, I'd like to wait until the administration takes us through bracket C and D. Just now you were very concrete. You mentioned completion of a program. But have you finished C or D yet? Well, you may ask questions, Mr. Lam. Thank you. One, very clear. One has 1 year of relevant work experience and is a registered professional engineer who is in the fire discipline. The next criterion is that the applicant needs to have a bachelor degree in any of the following disciplines and at least 6 years of relevant work experience. Based on what I know, 6 years of relevant work experience, it means in relation to the disciplines of the bachelor degree held by the applicant instead of the fire discipline. In relation to C, the applicant holds any academic qualification recognized by the director as equivalent to or higher than any of the qualifications mentioned in paragraph B1. Well, I have a question regarding academic qualification. Any discipline will do. Mathematics, chemistry. What if I hold a PhD in these disciplines? Then I have qualification higher than a bachelor degree, and I also have 6 years of relevant work experience. That may be totally irrelevant to engineering, but then I have a high academic qualification. Then, does that person still need to have qualifications in relation to fire engineering programs? D, the applicant attains a level of competence meeting the standard that is equivalent to that represented by any of the qualifications mentioned in paragraph B1. That is my question. During the interview, how does one show his or her competence? Thank you. The first criterion, very easy to understand. Relevant work experience. Yes, work experience in relation to fire engineer. Say formulating and implementing fire safety standard plans or inspection, repairing or repair and maintenance of any fire service installation or ventilating system. This is what is meant by relevant work experience. B, we set out some disciplines in relating to engineering. When an applicant has a mathematics PhD, the PhD holder will not be accepted as having met the criteria of B1. That is holding a bachelor degree in any of the following disciplines. Indeed, the applicant attains a level of competence meeting the standard that is equivalent to or higher than that represented by any of the qualifications mentioned in paragraph B1. Then we will let the interview board make the decision, but the objective criterion is 15 years of work experience. Mr. Lam, I'd like to return to C. Holding any academic qualification recognized by the director as equivalent to or higher than any of the qualifications mentioned in paragraph B1. Just now you said all the academic qualifications need to be relevant or similar to the disciplines mentioned under brackets B1. But this is not set out very clearly under the ordinance. Are you going to provide additional guidelines? Administration? Well, this is under brackets B1, so I believe this is clear enough. In relation to other application guidelines, I will give the floor to the Assistant Director. Thank you. Mr. Michael Yong. B1. We have included disciplines in relation to engineering or surveying as long as the applicant completes a bachelor degree, and when one has 6 years of relevant work experience, then that applicant may apply to be registered as a registered professional engineer, or registered fire engineer. In relation to C, when the applicant holds any academic qualification recognized by the director as equivalent to or higher than any of the qualifications mentioned in paragraph brackets B1, then the registration committee may make a decision. They may take into account the curricula of the program to see whether the contents meet our requirements? If yes, then the applicant may apply for registration by way of C, and this is to be decided by the registration committee based on the information submitted to the committee. Thank you. Next member, Professor Chow Man Kong. Thank you. I have the same concern. Section 21, brackets 1b. Well, I mean 22, brackets 1b. Many people have 2 degrees, that is, a first degree and then a second degree. Say one wants to have a career change, then someone may go for a second degree. Should we add words like or above? Say a civil engineering bachelor may obtain a master's degree in fire engineering. You cannot rule out the possibility that a university in Hong Kong may provide a master's degree in this discipline. When one does a master's degree, the student may already have the qualifications of an engineer, then one only needs to take 2 years to finish the master's degree program. Now I can see A to F, a total of 6 types from A to F. For these different names, in different universities or in different countries, these names may change. And in case of any change, do we need to come back to the Council to scrutinize these changes once again? Will you consider putting these 6 types in the schedule? Then in the future, in case of any changes, you may consider having a list of these disciplines or areas by way of positive vetting. Well, I mean negative vetting. Mr. Howard Yam, when one is a master, the master's program may last for 1 year, and it may not cover all the knowledge in a bachelor program, but we want to maintain flexibility as long as it is considered equivalent to or higher than any of the qualifications mentioned in paragraph B1 in the opinion of the director. Then one is considered having met the criteria. Whether the program is called a master's degree or a bachelor degree, it doesn't matter. We have listed 6 types of areas, but we understand there may be a lot of different names. So C allows the director to make a decision whether the applicant meets the relevant criteria. So why don't you simply put down equivalent to or higher than a bachelor degree? Probably you may go back and consider this point. Thank you. Dr. Loy Kwok. On the point of a master or a bachelor degree, it's not special in this case. It's not unique in this case, it could be found in other areas as well. Take the Hong Kong IE as an example. Some master's degree complement the knowledge of a bachelor degree program. It doesn't mean a master's degree program will cover all the contents of a bachelor degree. If one doesn't have basic knowledge of engineering, when one goes for a master's degree, one still cannot meet the qualifications. Starting from 2017, after the framework has been passed, it's been 8 years for the administration to think through the details of this scheme. I believe the administration has already thought through the details. Otherwise, if we're going to ask every single point, I'm not sure when we will finish the scrutiny of the bill. Thank you. Mr. Tongniche, well, I'm just repeating my point. I request providing the information of the bachelor degree. And now I reserve my right to follow up on the relevant matters. In accordance with Cap 123A, Section 12, Bracket 4, the Buildings Management Ordinance, when architects sign the fire safety equipment plan, comparing with Section 22, Brackets 1B and Section 2411B, I'd like to know why architect qualifications aren't included. I'll go back to study this point, and afterwards I'll decide how I'm going to handle this point. If need be, I don't rule out the possibility of making an amendment to amend these provisions. I hope the government will take into account Cap 123A in relation to the statutory right of the architect to sign the fire safety plan. I'd also like to draw your attention to Cap 572. That is about the statutory responsibility. I'd like to know how you are going to coordinate these different provisions. Simply put, we will provide information in writing. I hope we can objectively show you the differences between an architect and an engineer. As I responded, I already said we would review the need to amend Cap 123. Thank you. Professor Chow? Well, I didn't want to ask this question again, but just now member mentioned making a career change. That is what a lot of young people would want. Some young people may have bachelor degree in these 6 disciplines, but then when they want to go for a master's degree, then they need a prerequisite before they can be enrolled in the master's degree program. That is exactly these 6 following disciplines, as I mentioned. Well, I didn't want to go into great detail. I already asked twice in the course of clause-by-clause examination. I didn't ask this question out of no reason. Some retired firemen want to make a career change. Therefore, you really need to consider giving them an opportunity. They may do a bachelor degree and then they may make a career change. Well, my question is very professional as well. Professor Chow, thank you for your question. When one has a bachelor degree in one of the 6 disciplines as mentioned in bracket B, one may make an application by virtue of bracket B. As I mentioned, as long as one meets the requirements, one will not be affected by the title of the degree program when it comes to the eligibility of the person in question? Well, if I heard similar question asked by members, I will continue to ask questions. Thank you.
Dr. Lo Wai-Kwok. I'm looking at the drafting here, and I compare it with the administration's response. I think there should be flexibility to allow the director to make a balance. We don't want to give others the impression that certain members here are more professional than the others. We're all equal here. We're all given the equal opportunity to voice our opinions. I think it is reasonable for the administration to draft the provision this way, and I don't want to see further argument on this. I believe the administration has heard the views of different members. Well, please take into account the views expressed by all the members. Please proceed with the clause-by-clause scrutiny. Part 4, Duties of Registered Fire Engineers. Division 1, General. Section 25. A person may, for making a specified application in relation to any scheduled premises, appoint a registered fire engineer to carry out a duty. Section 26. A registered fire engineer must not carry out a duty that is not within the scope of duties of the class for which the engineer is registered. Anyone who violates this is liable on a fine of level 6 and imprisonment for 1 year. Sections 27 to sections 29, they list out the duties of the 3 classes of RFEs. Section 27 states that a registered fire engineer risk assessment may carry out the duties in relation to any scheduled premises to conduct an inspection of and carry out a fire safety risk assessment. To ensure consistency, sections 27 bracket 1, 2, and 3 state that the fire safety requirement formulated by the RFE must first be endorsed by the FSD. Section 28, registered fire engineer fire service installation must inspect the scheduled premises to verify the premises compliance with the fire safety requirement. Section 29, registered fire engineer ventilating system may carry out the duties in relation to any scheduled premises to conduct an inspection of the premises to verify the premises compliance with the fire safety requirements in relation to ventilating system. Section 30. A registered fire engineer must keep, for the period specified, a copy of every fire safety requirement and every fire safety certificate issued by the engineer. They have to submit copies of the documents kept upon request of the FSD. Otherwise, they will be liable to a level 3 fine or an imprisonment of 6 months. We drew reference from the Lifts and Escalators Ordinance, that's Section 26 of the Ordinance, when we drew up the penalties. Section 31. If there is a change in any of the following personal particulars of an RFE, such as name, phone number, correspondence address, and email address, the engineer must, within 14 days after the date on which the change takes place, notify the director of the change. Otherwise, the person may be liable on conviction to a fine at level 1. We again made reference to the Lifts and Escalator Ordinance when drawing up the penalty. Section 32. An RFE must at all times, while the engineer is at the place at which the duties are carried out, carry the registration card. And we made reference to the Lifts and Escalator Ordinance when drawing up the penalties. Mr. Andrew Lam. Section 30, it says that the
An RFE must not carry out any duties that is out of the scope of his duties. Well, an exaggerated way to interpret this is that I cannot even be a part-time chef if I am an RFE. Well, will the RFE only carry out a duty that is specified within the scope? Say, for example, an RFE of a certain class may supervise another person or another RFE to carry out the duties. Say, for example, I have the qualification of an RFE, but I want to learn about the duties of other RFEs. Well, will I be violating Section 26? It's best if you could ease all the concerns. Administration, I'll invite the law draftsman to explain why we have Section 26 in place, and we will respond to the members' questions. Thank you, Chairman. We have an interpretation for duties, and duties means functions. If you look at this provision in context, you may interpret it in a different lens. Well, this is very straightforward. Well, to respond to members' questions, can we interpret this in another way? Can we interpret the word duties in a different way? No, we have to look at the context to understand what duties mean here. There's a clear provision stating that different classes of RFEs have different duties. And you cannot carry out the duties of a class of RFE which you're not qualified for. So you cannot read this part out of context. This is not clear to me, Chairman. We have 3 classes of RFEs, and for each class of RFE, you have certain duties. Say, for example, an RFE for risk assessment. He is a registered engineer, and he does not have the license to check the ventilating system. And the company he belongs to want him to supervise the work of another RFE who is responsible for checking the ventilating system. Will he be violating this part of the regulation? Administration. Say we have an RFE who is directly supervising another person to carry out the duty of an RFE. Then the liability falls on the RFE to carry out the duty. The administration is not answering my question. If you look at Section 26, say we have an RFE for risk assessment. He is given a license. He is a registered fire engineer, but he does not have the licenses for the 2 other types of duties. According to Section 32, well, let's say we have an RFE for ventilating system, and that RFE asks the RFE for risk assessment to help supervise certain site inspection work. Well, this is not a duty that's supposed to be carried out by an RFE risk assessment. Is this against Section 26? Administration. If we look at Section 32(1)(b), well, I'm not saying if that person is violating 32(1)(b). I'm looking at Section 26. It says a registered fire engineer must not carry out a duty that is not within the scope of duties of the class for which the engineer is registered. Administration. I'll ask Mr. Yong to explain. If you look at Section 32(1)(b), an RFE may supervise another person to carry out duties. Mr. Yong. Say we have an RFE for risk assessment, and he helps with works concerning ventilating systems. And works concerning ventilation system can only be carried out by another class of RFEs. Will this be against the regulation? The purpose of Section 26 is to restrict RFEs to carry out duties that's within the scope of duties of the specific class. Member asked if the situation raised is against the law. Well, I think it might be due to some misunderstanding. Mr. Andrew Lam. Just now I asked a question about the definition of duty. It includes a function. If I assist another person in carrying out a duty, it can also be regarded as a function. I've asked this question a couple times already. Will Section 26 give rise to concerns and misunderstandings? If that's the case, I hope that you can enhance the clarity of this part. Administration, I think it has to do with how we interpret the provision. I'll ask the DOJ to supplement. DOJ. Let's look at Section 32(1)(b). Just now the member asked specifically about this provision. It says this section applies to a registered fire engineer who personally carries out any duties under Sections 27, 28, or 29. Sections 27 to 29 set out the duties of each class of RFEs, and Section 26 says a registered fire engineer must not carry out a duty that is not within the scope of duties of the class for which the engineer is registered. So this is different from personally carrying out any duties under Section 27, 28, or 29. Well, that means an RFE must not carry out a duty that is not within the scope of his class. And Section 32(1)(b) says an RFE may supervise another person to carry out such duties. So this is very clear. As long as the reader reads this together and in context, there shouldn't be any misunderstanding. You also have to look at Sections 27 to 29 together because these sections set out clearly the duties for each class of RFEs. Mr. Andrew Lam? Well, maybe I'm bad at language. I cannot agree with the explanation. If you look at section 26 together with sections 27 to 29 and also 32, my understanding is according to the law. Say I am an RFE for risk assessment. I may supervise another person who is not in the field or in the profession to carry out certain duties. The question is, if I am an RFE for risk assessment, can I carry out the duties of other classes of RFEs for other people? DOJ. Legal advisor. Well, if you amend section 26(2), it may be able to address the misunderstandings. If you add a provision about statutory defense here, it may be able to solve the problem. Well, this is to ensure that no one will be caught inadvertently by the law. My concern is, say an RFE is issued with a license for a specific class, and if the RFE wants to carry out the duties for other classes of RFEs, well, you should encourage the RFEs to do so instead of giving the RFE the statutory defense. Administration. Well, the purpose or the legislative intent is clear. Under section 32(1)(b), it says clearly that anyone may carry out the duties. It is clear that an RFE will not be prohibited to carry out such duties just because he has obtained the registration for a certain class. Well, please see how you can improve the provisions here. Well, please also provide a written reply on the point raised by Mr. Lam. Sure. If this can be done by anyone, an RFE will not be prohibited from carrying out the duties just because he has obtained the registration for a certain class of RFEs. I think the goal is to have more people join the profession. As to how we can improve the drafting, administration, please think about it. Ms. Doreen Kong. Section 25 says clearly that the RFEs will only be able to carry out duties specified in sections 27, 28, and 29. My concern is about the penalty level. Also, I want to give an analogy. Take surveyors as an example. There are many different types of surveyors, but they aren't subject to the restrictions as set out in section 26. They shouldn't be subject to such restrictions. So my opinion is that we should do away with section 26. Even if we have to include section 26, please enlighten me in why we have to include that. I think we should at least do away with section 26 bracket 2. I have a question about section 27, 6A. It says an assessment or an inspection is conducted by an RFE only if the inspection is personally conducted by the engineer or another person who is under the direct and proper supervision of the engineer at the place at which the inspection takes place. What's the point of adding this provision? This is because the engineer must be there in order to issue the certificate.
Next, section 30, bracket 1. After issuing the certificates, this RFE is also required to keep documents. So he needs a big office. Is it possible to keep e-copies instead? About section 26, according to the administration, they will go back and take a look and then give us a written reply. So please note their stance, and then let's answer the two other questions, please. About the inspection being carried out under the direct and personal supervision of the RFE, this is in fact the practice adopted by the profession. So there is a need to continue with this practice. About keeping e-records, I'll give the floor to the director. The answer is in the affirmative. The RFE can keep e-copies of the documents, such as, for example, the submission originally made physically. In keeping these records, the RFE can keep e-copies instead. Mr. Tony J. Simply put, I welcome the administration's answer. They will be rethinking the duties and the obligations of the RFEs as per section 27 because of the ambiguities here. In fact, sections 27, 8, and 29 refers to scheduled premises. Are they referring to existing premises or structures being built for some scheduled uses? So are new structures included? About scheduled premises, we find the schedule in the regulation, and the premises there are scheduled premises. I don't think you've answered my question. I'm referring to whether they apply only to existing premises, licensed premises. Is that right? So scheduled premises do not include structures being erected for scheduled uses. So only covering existing premises, right? Next, Dr. Loy Kwok. I'd like to give my take on this word duty. Section 25 of Part 4 refers to appointment of RFEs. This provision spells out very clearly what duties are covered. And then we have the three classes: risk assessment, FSI, and ventilation system. So of course you need to be a registered fire engineer in order to carry out the duties under the respective classes. But it's misleading here because when it comes to duties, they may cover a very wide scope. In a company, an RFE may be responsible for risk assessment and ultimately appending the signature in the document, but other professionals may have also participated in the process. Is teamwork. So if you confine the scope of duties to what's set out in the provision, it will be too narrow. I'm just saying that if you are not registered, you're not licensed to carry out the work. This is the possible misunderstanding that may arise from section 26. Any response? Not for the time being. We'll go back and reconsider the position. Mr. Chan Sil-ho. according to their explanation, when I read section 26, I think the administration is referring to the carrying out of duties by the RFE of that particular class, and if the duty falls outside the scope of that class, then the RFE is not entitled to carry out such duties. Now, after conducting assessment, etc., the so-called fire safety certificate will be issued. The certificate is issued for the scheduled premises and for the scheduled users. Now, coming back to Part 2, Division 4, about the contravention of fire safety requirements or the certificate, a level 6 fine will be attracted together with 1 year imprisonment. So it shows that if you're not in that particular class, you can't issue these certificates. And after you've issued certificates, you still need to go through certain steps. For example, for desktop analysis or on-site inspection. And for FSEs not meeting the experience requirement, they need to acquire at least 6 or 15 years of experience before they are allowed to carry out a series of duties under the supervision. So for a person not meeting the registration qualification requirement and issuing a certificate, this person will be on conviction subject to a level 6 fine and 1 year imprisonment. So like other members just now said, you need to rethink whether section 26 is necessary. And please explain and allay our concerns. It's very clear. Our stance is that if a person carries out duties, whether qualified or not, we want this person to have sufficient experience so that this person can be registered as an RFE. Right, I think this comment is well noted. We'll go back and rethink section 26. I think members have explained their comments very clearly. Right, please continue if there are no further comments. Division 3, page 26, about issue of fire safety certificates and fire safety requirements. It sets out the requirements that the RFE should follow when issuing certificates. Section 33. After conducting inspection and testing, the RFE of the FSI or ventilation system class should issue the certificate within 5 days, and the copy should be submitted to the director. The relevant specified form must be followed. It must be signed by the RFE who inspected the premises and carried out the assessment. Section 35 relates to offences such as issuing fire safety requirement without the director's endorsement, issuing a fire safety certificate that is false or misleading, or issuing a certificate while knowing that the relevant requirement has not been endorsed by the director. On conviction, this person is liable to a fine of $200,000 and imprisonment for 1 year. We've made reference to the offences and penalties for the relevant breaches. That's the lift and escalator ordinance. Mr. Rincon, I have a question, Chairman. Section 35. The director's endorsement is required here. I stand to be corrected. But Section 27, subsection 2 specifically refers to the director's endorsement, but when it comes to FSI in section 26, only an audit is required. Am I missing something? That is, for ventilating system and FSI, this may have to do with aging, but I really can't see the word endorsement. Administration. I think the member's asking for the difference between, among the three. For fire safety requirement, the director's endorsement is required. The director's endorsement, however, is not required for the other two. But we will conduct audit on 70% of the cases at random. That's our legislative intent. Right, excellent. So section 35, 1A and C, shouldn't you expressly provide that the director's endorsement is required only for fire safety requirement but not for the other? Because from a layman's perspective, things are not clear. So can you improve 1A and C's clarity? Is there any reference to these parts apart from 1A and C? I think that is clear enough because A and C refers to fire safety requirement, which is related to the to risk assessment. Part 5, page 28, power to obtain personal particulars. Section 36. For the purpose of carrying out investigation, the director may, has the power to require the provision of the person's name and address or ID document. A person who provides false information on conviction commits an offense and is liable to a fine at level 4, and we've made reference to the relevant legislation and penalty levels. That's section 21 of the fire hazards regulation. Right, section 36(2), may I ask if it's possible to include the registration card as well? Because here there is no requirement for this person to provide the registration card. Perhaps you should maintain some flexibility. Now, we require the person to provide the name, address, and ID document for follow-up action. As long as the particulars mentioned are available, at the back end, the fire services member will be able to retrieve other registration information. Right, please continue. Thank you. Page 30, Part 6, Disciplinary Proceedings. Part 6 refers to disciplinary offences and complaints. Division 1. The crux of this division is to spell out the disciplinary offences and establish a complaint mechanism. Section 37, Disciplinary offences. An RFE commits disciplinary offence if he commits misconduct, neglect, contravenes registration, or issued fire safety certificate for compliance with the requirement and failed to discharge the duties, held himself out as a registered fire engineer for which he or she has not been convicted of an offence in Hong Kong or elsewhere, of any offence that may bring the profession of registered fire engineer into disrepute. We've made reference to relevant legislation in drawing up section 37, including the Engineers Registration Ordinance and the LESO. Section 38, if this person, on applying for registration or renewal of registration as an RFE, has on his own initiative disclosed matters relating to the above, the person will not be held liable for the active disclosure. This encourages any person who applies for registration or renewal of registration to disclose any previous offences. Section 39. Any person may make to the Secretary a complaint of a disciplinary offense against an RFE. The complaint should be referred to the Secretary within 30 days. The grounds should be set out if the complaint is not referred, such as the complaint being made anonymously, the complainant not being able to identify, trace, or it's a vexatious, frivolous complaint not made in good faith. And Section 41, if a complaint is referred to the Secretary must within 21 days appoint a board to hear and consider the complaint. And then page 32, Division 2, hearing of a disciplinary board. Section 42 provides definition of terms such as parties being the director and the RFE who is subject of the complaint. Section 43, proceedings before disciplinary board. The chair must appoint the date and time of the hearing. And then the party to the hearing may make a representation and be represented by a solicitor or counsel and may also adduce evidence. Section 47, the chairperson may appoint a solicitor or counsel as a legal advisor to advise on any legal matters relating to the board. Again, we've made reference to similar legislation such as LESO. According to Section 44, the disciplinary board may collect evidence, receive evidence on oath, and order the person to appear before the board and give evidence and provide documents, etc. A person who, without reasonable excuse, contravenes an order, commits an offence, and is liable on conviction to a fine at level 5. We've made reference to the LESO. Section 45. The disciplinary board must not inquire into the question whether the RFE was properly convicted of the previous offence when handling a disciplinary hearing. But after hearing the complaint, if the RFE is convicted of a disciplinary offence, the board may, for considering what order to make under Section 48, such as issuing a reprimand, a warning, or other disciplinary actions, consider any record of the previous offence and any other evidence that is relevant as showing the nature and gravity of the previous offence. That will help the board in deciding the appropriate penalties. Section 46, Code of Practice. In deciding on a disciplinary case, the board may have regard to the Code of Practice in force. Section 48. After the hearing, the disciplinary board may issue orders. If the board decides that the RFE has not committed the disciplinary offence, then the RFE may be exonerated. And if the board decides that an offence has been committed, the following orders may be made, and the order should be explained within 14 days. The parties should be notified as of the reasons for making the order, the effective date, etc. Section 49. After receiving this notice of an order, within 30 days, if an appeal is not made, then the board is required to publish the order of the decision in the Gazette, and then within 30 days, the order must be published. Section 50. Members of a disciplinary board enjoys the same functions, same privileges, and immunities as a judge of the CFR in civil proceedings. The party's representative and the board's legal advisor are entitled to the same privileges and immunities as a person and legal advisor respectively would have in civil proceedings in the CFI. We've made reference to the LESO and the LES regulation. Please pause here. Mr. Andrew Lam. Thank you, Chairman. Just a general understanding on reading these provisions. Whilst the registration of this RFE is still in force, the engineer is obliged to carry out some duties, and that means we refer to Section 30, such as record keeping, etc. But once the name has been removed from the register, how do the penalties apply to the RFE? Because to be frank, this person may know very well that he's in breach of certain provisions and that he may apply for his name to be removed from the register. Does it mean that he will be absolved from the liabilities?
佢自
In relation to criminal offense, we will continue to follow up on such criminal offenses because one cannot rid oneself of such offenses by himself or herself. So which ordinance will you be invoking? If that person is a registered fire engineer and if they break law, then we may prosecute that person. It won't be the case that when one ceases to be a registered fire engineer, then they will be absolved of the criminal liability. This won't be the case. When that person is a registered fire engineer, it is not possible for one to apply to cease to be a professional fire engineer in order to be absolved of the criminal liability. Mr. Eng Kong, I understand. I'd like to ask about Section 49(3). I understand just now you mentioned the LEO. But apart from the LEO, for planners, such adjudications will also be posted and announced. Actually, in one, that is the original decision, it may be announced as well. When the disciplinary board makes a decision, you already need to announce the relevant decision, but there's a chance that the applicant may lodge an appeal. In other words, when one is found to when one makes an appeal and the appeal overrules the previous decision, damage has already been done to the reputation of the registered fire engineer. If you announce the result only after an appeal is handled, that will offer better protection to the professionals, and you need to settle clearly whether an announcement needs to be made in an English and a Chinese newspaper. Administration, the difference between 1 and 3. It's about extra information in relation to appeals, if any. We won't suspend the decision on the disciplinary board. We won't do so directly. But if the disciplinary board has heard submission from an applicant, if necessary, they may suspend the execution of some decisions. In this case, a balance will be struck between two factors. In other words, the procedures can still go on. If, however, the applicant has solid grounds, there is still a chance that the disciplinary board may suspend the execution of the decision. Thank you. Lawsuits are heard in public. They are open. However, for disciplinary actions, they are held behind closed doors. They aren't open to the public. I don't want the reputation of professionals to be affected so lightly. Thank you. Please continue. Please refer to Part 7 Appeals, that is page 45 of the English copy. Interpretation of Part 7. Appeal to Appeal Board, commencement of appeal by persons other than Director. We have drawn reference from the LEO as well. According to Section 51, original decision in relation to appeal made under Section 52, brackets 1 means 1. A decision of the Director to refuse an application for registration. Original order means in relation to an appeal made by Section 52, brackets 1, an order made by a disciplinary board under Section 48, brackets 3, or in relation to an appeal made under Section 52, brackets 3, an order made by a disciplinary board under Section 48, brackets 2. Party means in relation to an appeal made under Section 52, brackets 1, the Director, or 2, the person making the appeal, or in relation to an appeal made by under Section 52, brackets 3, the Director or the disciplinary board, the order of which is appealed against. Division to appeal in hearing. 52 Appeal to appeal board. A decision of an appeal board is final. Section 53 Commencement of appeal by persons other than Director. A 30-day period beginning on the day immediately following the day on which the person was notified of the original decision or original order as appropriate appealed against, or a longer period the Secretary allows. On receiving a notice of appeal that complies with subsection bracket 3, the Director must deliver notice to the Secretary within a 14-day period beginning on the day immediately following the date of receipt. Section 54 Commencement of appeal by Director. 1. If the Director intends to appeal under Section 52, bracket 3, the Director must commence the appeal by delivering to the Secretary a notice of appeal in the specified form within a 30-day period beginning on the date immediately following the date on which the Director was notified of the original order appealed against. Section 55 of Appointment of Appeal Board. As I mentioned, we have drawn reference from the LEO. Division 3 Hearing of Appeal Board, page 48 of the English copy. Proceedings before Appeal Board. According to Section 56, the chairperson of the board is to appoint the time and place of the hearing. A party to the hearing may make a representation in person at the hearing, or be represented at the hearing by a solicitor or counsel, or any other person authorized by the party in writing. The hearing is to be open to the public unless the appeal board determines that there is good reason for it to be held in camera. According to Section 59, Legal Advisor to Appeal Board, the chairperson of an appeal board may appoint a solicitor or counsel as a legal advisor to advise on any legal matters relating to the proceedings of the board. According to Section 57, Giving of evidence of related offense, the appeal board may receive evidence on oath and by notice signed by the chairperson of the board or any person to attend before the board and to give evidence or to produce any document or information relevant to the appeal. We have drawn reference from the disciplinary board arrangements as well as the relevant legislation. According to Section 58, Code of Practice in the hearing, the appeal board may, in any proceedings under this regulation, to decide whether a registered fire engineer has committed a disciplinary offense, have regard to any provision of the code that appears to the board to be relevant to the act or omission constituting the offense. 60. Orders by appeal board after hearing. If the appeal board decides to revoke or vary the original order or to substitute the board's own decision for the original order, the appeal board may revoke, vary, or substitute the board's own decision for the original order. We move to amend Section 60, brackets 1, brackets 2. The relevant information is contained in CP brackets 21471/2025 brackets 02. Have you finished? I still have a little more to go. If the appeal board makes a decision under subsection 1, the board must, within 14 days after the date of the decision, notify the parties to the hearing and any representative of the parties in writing of the following: the making of the decision, including any order made under subsection 2, the reasons for making the decision, and in relation to an order made under subsection 2, the details of the order. 61. Privileges and immunities of members of appeal board. We have drawn reference from the LEO and relevant legislation. Mr. Kong. Thank you, Chairman. I'll be quick. I'd like to ask about the English text. 56.1. Should the preposition be to instead of by? It is an appeal made to the appeal board instead of by an appeal board. Just now you mentioned you would move an amendment, but I haven't yet read the amendment. In section 60, whether 1, 2, 3, they deal with the appeal lodged by another person, that is those under section 52. Appeal made by director will also lead to orders. If section 60 only deals with orders by appeal board after hearing, then what about those to be made by directors? Well, exactly, we're going to move amendments to amend section 60, and we will also be covering appeals to be made by director. Well, section 56, brackets 1, for hearing an appeal made under section 52 by an appeal board, it shouldn't be by an appeal board, instead it should be to an appeal board. We should read it this way: for hearing by an appeal board. Let's assume there's a comma. For hearing, comma, an appeal made under section 52, comma, by an appeal board. What about for hearing an appeal by an appeal board made under section 52? What about reversing the word order? Otherwise, it doesn't make sense. Well, according to English grammar rules, it reads well. It makes sense. Dr. Wendy Hong, I'd like to ask about Dr. Wendy Hong. Well, I'd like to know whether any costs will be involved in appeal or in appeal. In appeal and in hearing, where we'll be supporting the appeal board. So there shouldn't be any costs on the applicant. Members, our meeting is scheduled to end at 6:30. I will extend the meeting by 15 minutes. Thank you, Mr. Tony Te. Thank you. A straightforward question. For appeals, there's a time limit. Say if the limit is 30 days, or 14 days in this case, is there any restriction or no restriction as long as the director wishes? Well, there's no restriction. The director will decide based on each case. Chairman, well, if you agree to set a time limit, of course, there's a reason behind it. You include the time limit in the legislation. Otherwise, you should have allowed people to lodge an appeal with a longer period of time. Otherwise, there's no reason behind it. Well, when it comes to the legislative intent, you have a time limit for other people, but then you don't have one for yourself. It's not fair. Administration, we need to take into account the facts of each case. It may be beneficial to the applicant. Probably on medical grounds, the applicant may not be able to do so. So even if 30 days have been passed, the applicant may still apply to the director, who will then submit the application to the secretary for consideration. If there's a time limit, an impact would be made to the applicant. Well, I'm not sure whether there are any benefits. You say that there are benefits, but to some people, they may say that you are simply dragging your feet. If the appeal is allowed, the applicant may want to have his or her name cleared as soon as possible. This is good to the applicant. Yes, I have already explained. Thank you. Administration, please go on. We need to make good use of our time. Part 8. Registration Committee, Board Panels and Boards on page 51. Division 1, Registration Committee. 62. Establishment and Composition. The Director must establish a fire engineering registration committee to perform the function under Section 63. The registration committee is to consist of the following members: 1 chairperson, 1 secretary, 10 other members. Each member of the registration committee is to be appointed by the director in accordance with the following categories. 1. The chairperson and secretary must be fire services members. B. One of the other members of the committee must be a fire services member. C. 4 of the other members of the committee must be nominated by the Engineers Registration Board. D. 5 of the other members of the committee must be nominated by other relevant professional or academic bodies as the director considers appropriate. Section 63, Function of Registration Committee. Section 64, Terms of Members of Registration of Committee. Section 63, Term of Members of Interview Board Panel. No more than 3 years. Section 68, Procedure of Interview Board Panel. Please refer to page 53, Division 3 Interview Board, Section 69. Composition of Interview Board, consisting of a chairperson, 2 other members. The chairperson must be a fire service member. One of the members must be a fire services member, and one of the other members must be appointed from the Interview Board member. Section 70, Functions of Interview Board. It sets out the functions of the interview board. Section 71, Meetings. An interview board is to meet as often as the chairperson of the board directs. Section 72, Disclosure of interests of member of the interview board. Declaration must be made to the interview board as soon as possible. He or she must not participate in any deliberation regarding the interview. Hang on, Mr. Rincon. I'd like to ask 2 questions. 1. Regarding the interview board or the interview board panel, does it hold any meeting? It doesn't. Only the interview board holds meetings. So why do we have Section 68? The other is Section 75, Disciplinary Board Panel. A panel doesn't convene meetings, only the board does. This is my first question. My second question is in relation to Section 72. In case of pecuniary interest, what about personal interest? What about a member of the interview board has personal interest in relation to the applicant? Does he or she need to disclose the relevant interest?
Administration. The provisions about the board panel, it is just to empower the board panel to do so. We want to have a mechanism in place, and in case necessary, the board panel can come up with their own procedure. On the second question about the disclosure of interests, we ask members of the board to declare any interests. What if I have personal relationship or I'm a relative of the applicant? Will that be a conflict of interest? Are you going to follow the ICAC guideline? We attach importance to any conflicts of interest, so we will see if the provisions match our legislative intent. Mr. Tony Che. Normally, members of these boards can sit on the boards for no more than 3 years. Will board members be able to renew their terms? Administration. Yes, they can. Normally, within the government, for this kind of boards or committees, members have a term for 6 years. Please proceed. Section 73. Establishment and composition. The Secretary must establish a panel from which the Secretary is to appoint members to a disciplinary board. A disciplinary board panel is to consist of at least 3 members. Each member of the disciplinary board panel must not be a public officer and must be nominated by relevant professional or academic bodies. Section 74. A member of the disciplinary board panel is to be appointed for a term of no more than 3 years and may be reappointed after the expiry of a term. Division 5. Disciplinary board. Section 76. A disciplinary board is to consist of 5 members and a secretary to the board. Each member of the disciplinary board is to be appointed by the secretary. 2 of the members must be fire services members, and 3 of the other members must be appointed from the disciplinary board panel. If a fire services member is or was engaged, whether directly or indirectly, in the investigation of a complaint to be considered by the disciplinary board. Section 77. Members of a disciplinary board are to elect the chairperson of the board from among themselves. The chairperson is to preside at any meeting of the disciplinary board. All questions for decision are to be decided by a majority of votes of the board members present and voting. Section 78. The quorum of a meeting of a disciplinary board is 4 board members. Section 79. If a member of a disciplinary board becomes aware that the member has a pecuniary interest, whether direct or indirect, in any matter under consideration, the member must, before or as soon as practicable after the meeting begins, disclose to the board the fact and the nature of the interest. Ms. Doreen Kong. If there is not a quorum, how will the situation be dealt with? Administration. If it is a disciplinary board, we have to establish the board again to make sure that there is a quorum. Please proceed. Division 6 Appeal Board Panel. Section 81. The Secretary must establish a panel from which the Secretary is to appoint members to an appeal board. An appeal board panel is to consist of at least 5 members. Each member of the board panel must not be a public officer and must be nominated by relevant professional or academic bodies. Section 82. A member of the appeal board panel is to be appointed for a term of no more than 3 years. Section 83. The appeal board panel may regulate its procedure and make standing order for that purpose. Division 7 Appeal Board. Section 84. An appeal board is to consist of 7 members and a secretary to the board. Each member of the appeal board is to be appointed by the secretary. 2 of the members must be fire services members, and 5 of the other members must be appointed from the appeal board panel. If a fire services member or member of the appeal board panel was engaged in the making of an original decision that is the subject of an appeal to be considered by the appeal board, the secretary may not appoint that fire services member or panel member to be a member of the appeal board. Section 85. Members of an appeal board are to elect the chairperson of the board from among themselves. All questions for decision are to be decided by a majority of votes of the board members present and voting. Section 86. The quorum of a meeting of an appeal board is 5 board members. Section 87. If a member of an appeal board becomes aware that the member has a pecuniary interest, whether direct or indirect, in any matter under consideration at the meeting, the member must, before or as soon as practicable after the meeting begins, disclose to the board the nature of the interest. Section 88. And the appeal board may determine its own procedure. Part 9. Miscellaneous provisions. Section 89. The director may issue a code of practice that in the director's opinion is suitable for providing practicable guidance. When the director issues a code of practice, it must be published in the Gazette. Section 90. The director may specify the form of a document required for the purposes of this regulation. For example, an RFE for risk assessment must use the specified form for issuing the certificate. And for the other 2 types of RFEs, they also have to use the specified forms for issuing the certificates. Section 91. The director must, for the purposes of this regulation, establish and keep a register of registered fire engineers. The register must contain the name of the RFEs, the registration number, the class for which the engineer is registered, and the expiry date of the register. The register is to be published in the Gazette at least once in every year and is to be published from time to time and in a way as the director considers appropriate. Section 92. The director may in writing appoint a public officer to be an authorized officer. Section 93. The director may in writing delegate to a public officer any of the director's duties or powers. Section 94. When performing a duty or exercising a power under this regulation, a public officer to whom such a duty or power is delegated may be assisted by any person whom the officer reasonably requires and must produce proof of the officer's identity for inspection. Before the 2 members speak, I'd like to consult members. We are close to the end of the clause-by-clause scrutiny. This meeting is supposed to end at 6:30 p.m. If I extend this meeting by another 15 minutes, will members object to that? Let's see if we can conclude the scrutiny today. Yes, Mr. Tony Che. Are you extending this meeting by another 15 minutes because you do not want to hold another meeting? Well, I'm waiting for certain responses from the administration, so I think there is a need to hold another meeting. If you simply take into account the completeness and integrity of the scrutiny, you want to extend this meeting by another 15 minutes, I have no objection. However, I do think there is a need to have another meeting. Well, for completeness' sake, I want to carry on with the scrutiny. As to whether we will have another meeting, it really depends on the administration. I ask that we have another meeting. Yes, Dr. Lo Wai Kwok. It is true that we will have to hold another meeting because there might be CSAs. However, I am happy to extend this meeting so that we can complete at least this part of the scrutiny. Do members have other views? Yes, Mr. Chen Xiuhong. I, in principle, do not object that we carry on with the scrutiny. We want to catch up with time. However, as Mr. Tony Che said, we have to do this for a purpose. Apart from this regulation, we have to go through certain tables. They are rather straightforward. Like the 2 other members said, we expect that there will be another meeting. As the administration promised, they will follow up on our questions. So I believe there will be another meeting. And the administration also said they will propose amendments and will need time to discuss those amendments. Chairman, do you think we can stop after a certain part or a certain table? Then we can conclude the meeting today. I suggest that we cover the schedules today. I also think that we will have to hold another meeting. This is because members raised different opinions on the regulation just now, and the administration holds different views on those issues. We will have to hold another meeting to discuss the points covered. If members do not object, I will extend this meeting until 7 p.m. And in the next meeting, we will follow up on the issues raised in this meeting. Yes, please carry on. It's time for questions. Do members wish that the administration goes through the entire regulation first? Okay, I'll open the floor for questions. Mr. Chen Xiuhong, I'd like to ask about Section 91. Director to establish and keep register. 2 questions. As mentioned, from time to time, the administration may need to remove certain names from the register or even update the register. From the user's perspectives, we do want to know what RFEs there are, and license applicants would like to have the most updated list. According to this section, the register will be published at least once every year. Will this register be published online, or will license applicants be able to read the register at a certain place? Also, it said here that the register will contain the name and the registration number of RFEs. Will that cover both the Chinese and English names of the RFEs? And how will you include all the information on the register? Administration, the register will be uploaded online, so license applicants will be able to see any real-time updates. Our current thought is that we will cover the contact information of the RFEs. If we include all the information A, B, C, D here, it will ensure transparency. Yes. So there will be a list of RFEs names, and the register could be checked by the public online. You don't need to have a password to access the register, right? Yes, the public will have access to the register, and they may check the register anytime. Ms. Doreen Kong, I want to ask about Section 95, 1A and 1B. It mentions about serving the notices by fax. We encourage people to use email nowadays, so should we still include serving the notice by fax here? Also, I'd like to ask about D. D says here that the company will have to serve the notice to the officer. Well, do you adopt the definition of officer under the company's ordinance? Well, for company officer, we refer usually to the manager or the company secretary. So should you include these 2 posts in the provision? Dr. Lo Wai-kwok. Well, I think it's not restricted to serving notices by fax here only, right? Administration. We encourage electronic records so documents can be served by different means. Also, the notices will be served to any officer of a company, and we stick to the literal meaning of it. Yes, Mr. Rincon. I think service of legal documents is important. Can you tell us which legislation also adopts the phrase any officer of the company? Because this has to do with the service of legal documents. Well, can you please look into that, or do you have the relevant information in hand? We made reference to the existing legislations. Say, for example, Cap 572 under the Fire Services Ordinance. The same phrase is adopted. Administration, please proceed. Section 96. Requirements specified for digital signature under Section 95(7). The requirements specified for the definition of digital signature in Section 95(7) are that the digital signature is supported by a recognized certificate. Also, the digital signature is generated within the validity of the certificate, and the digital signature is used in accordance with the terms of that certificate. Section 97. A registration card must be in an electronic form specified by the director. The director may issue a registration card in a hard copy form specified by the director to a registered fire engineer if the engineer has shown sufficient ground. Section 98. Any fee paid under this regulation is not refundable. Section 99. This section applies if a provision of this regulation that creates an offense makes a reference to a reasonable excuse for a contravention or failure to which the provision relates. If a defendant is taken to have established that the defendant had a reasonable excuse for the contravention or failure, if there is sufficient evidence to raise an issue that the defendant has such a reasonable excuse. Scheduled premises, Part 1. Scheduled premises for which license is required. For the first phase, we will implement the RFE scheme for food business premises. After the first phase, we will assess the effectiveness of the scheme, and depending on the outcome of our review, we may consider extending the scheme to other scheduled premises. I've already briefed members of the clauses involved. Mr. Rincon, I'm looking at Section 95. Cap 572, Section 23A is about how the documents should be served to companies, but the term officer is not used there. Instead, 23A1A, it says it will be served to the management or those employed by a body corporate. So I would like the administration to think about whether it should stick to the way it's drafted in Cap 572. We will look at the best way of drafting it, but we're currently leaning towards sticking to the term any officer. Any further questions on the regulation? If not, we have completed the clause-by-clause scrutiny. Let's have the legal advisor confirm that the English version of the proposed regulation and the Chinese version align with each other. We've written to the administration on the matters raised, and other than those, we did not detect any problems with the Chinese and English versions. As for the proposed amendments to be raised by the administration, we will look into them. As mentioned, as the administration prepares for the document, we will set a date for the next meeting. Members, please note that if you would like to propose any amendments and if you want the amendments to be considered by this subcommittee, please, before the next meeting, submit the draft amendments to the Secretariat. The Secretariat will ask the administration to provide a written response to the draft amendments so that the subcommittee can consider the amendments. We'll also ask the administration to provide a response. Afterwards, we'll set a date for the next meeting. Also, to implement this RFE scheme, apart from the proposed regulation, the administration already on Friday, that is the 18th of July, published in the Gazette the 5 relevant subsidiary legislations. The 5 subsidiary legislations will be tabled to this Council this Wednesday. The House Committee at the meeting this Friday will consider whether a subcommittee should be formed to consider the subsidiary legislation. Depending on the decision made by the House Committee, this subcommittee may have to scrutinize those subsidiary legislations. If members do not have any questions, meeting adjourned. Thank you.